Hello, it is Tuesday morning, August 13th, 2024, and this is Alan Zundell with Political Dharma. I'm bringing you a special report because yesterday there was a court decision affecting independent candidate Robert F. Kennedy Jr. ability to be on the ballot in the state of New York. So let's look at one of the news stories here from the Associated Press, and you see the headline that the judge in New York ruled against RFK Jr. in his fight to be on New York's ballot. Now, this case was brought by voters affiliated with the Clear Choice PAC who paid for the whole thing. That PAC has a number of Democratic operatives, and they brought the case in New York as well as in a number of other states. So this one was important because, as I'm going to get to, it applies to other states as well. So let's look at that judge's decision. Here we see the first page of it. This is the decision, State of New York deciding on the matter of, and here's the name of the voters that the Clear Choice PAC rounded up to bring this complaint against Robert F. Kennedy Jr., Nicole Shanahan, and a bunch of others affiliated with the campaign and the establishment of the We the People Independent Party, Kennedy's new party in New York, and also the State Board of Elections. So there are the respondents in the case. Their decision here, as you see, if you're watching this in video form, the court's ruling, the Court of Appeal, here, I'm going to quote from it in a few highlighted passages on your screen if you're watching this in video form. The Court of Appeals has repeatedly emphasized that although substantial compliance with election law requirements is acceptable as to details of form, there must be strict compliance with statutory commands as to manner of prescribed content. Here, the court is making a distinction between form and content when it comes to a petition to be on the ballot. I'm not sure exactly what they mean by form, but clearly what they mean by content is when you have to fill in information, that information is the content of the form you're submitting. So perhaps they're meaning by form that you can have some variation of the way that the petition is actually designed, but you still have to have accurate content in it. So that part is clear. And they go on to say the requirement that each page of a nominating petition set forth the candidate's place of residence is a matter of prescribed content rather than form, and therefore strict compliance with the requirement is necessary. They're saying when you fill in information about your place of residence, you have to be accurate. And it goes on a little later to say strict compliance standards simply requires the court to determine whether the 84 Croton Lake Road address was in fact Kennedy's legitimate place of residence under the election law at the time when the nominating petition was circulated and filed with the Board of Elections. All right, here clearly they're saying that the court doesn't have to decide a lot of various issues other than whether Kennedy actually was a resident of the address he listed on his petition in the standard of residency as determined by the state elections law. Down there further on the page, petitioners bore the burden at trial to demonstrate by clear and convincing evidence that the address listed on Kennedy's nominating petition was not his residence within the meaning of election law. So it's on the people bringing the case to prove to the court that the residence listed on the petition was clearly not the residence that Kennedy lived at. So what exactly was the requirement of the elections law here? Under the elections law, a person's residence is based largely on his intent to remain at or return to a specific abode. And this was the argument that Kennedy was making, that he did intend to return to New York to live after his wife retires from acting. He's now living with her in California. And must be coupled with an actual physical presence at the abode. Now, here was the hang-up that Kennedy ran into, that New York elections law has a definition of residency that's much more, according to what I called on Sunday the layman's definition, that you actually have to be present there, eating meals, sleeping, and the rest. And this is what they had to prove, that he wasn't really physically present, not about just his intent, but about his physical presence at the residence that he listed. Going on further, petitioners demonstrated by clear and convincing evidence that the address listed on the nominating petition was not Kennedy's bona fide residence within the meaning of election law. Further on, the overwhelming credible evidence introduced at trial established that Kennedy's connections with the address existed only on paper and were maintained for the sole purpose of maintaining his voter registration and political standing in the state of New York. And to interpret what I just read to you is saying that, well, those who brought the suit did bring plenty of evidence that was very convincing to the judge that Kennedy's didn't actually physically reside at that address, and he only kept the address as his so-called residence for the purpose of keeping his voter registration and being politically active in the state of New York. I guess he's keeping his options open for the future. At least that's how they interpret it. And finally, it's signed here, and the order states that the Board of Elections is hereby directed not to place and/or print the name of the respondents' candidates aforesaid as candidates of the We the People Independent Party on the official ballot to be used at the general election held on the 5th day of November 2024. All right, so that's what the court decision was about, and many people on my Sunday show just 2 days ago when I talked about this case briefly, and I hadn't looked into it in detail at that time. Many people are asking in the comments why the residence was an important thing in New York. They're saying, well, Trump is not a resident of New York and Harris is not a resident of New York. Well, the problem here was the way that Kennedy filled out his petition. On his petition, where they gave the signatures, he listed his address as a candidate at that New York address, which they proved to the satisfaction of the judge was not actually a residence for Kennedy within the meaning of New York elections law. Now, this case is going to be important. Well, it is important just from the standpoint of Kennedy, keeping Kennedy off the ballot in at least one state when he's promising to be on all 50 states plus the District of Columbia, and he's very close to getting that. So this is going to be pursued further, I'm sure. It's important because in other cases as well, for example, in the state of Maine, where they just announced that the Secretary of State there was going to determine this challenge to the ballot petitions that for Robert F. Kennedy Jr. and Cornel West. One of the issues at stake in Maine was that he did not list his correct address. There was also other issues at stake, such as that a lot of his signatures were invalid, so they claimed. But this place of residence is an issue not only in New York, but in Maine, as well as in ongoing cases in Pennsylvania and Illinois. So if they start determining, according to elections laws in the various states, that Kennedy is or is not a resident, this would be potentially knocking him off the ballot in other states, but also establishing different standards in different states. So what Kennedy has said in his campaign website here is that he's going to appeal the decision. And looking down at the statement on the Kennedy's campaign's website, Judge Rybaugh openly in court said she refused to consider the constitutionality of the New York residency requirement under the 12th Amendment. So here the claim is they're going to appeal to federal court. It's not a claim, but that they're intending to appeal this to federal court on the grounds that the court, the New York court, did not consider the constitutionality of New York's residency requirements for a candidate for president, because it should be determined by the U.S. Constitution and not New York state election laws. So what is it that the 12th Amendment to the Constitution actually says? Well, this is a long one, and it has to do with how the electors in the Electoral College cast their votes in each of the states. If you see on your screen at the very beginning of the 12th Amendment to the U.S. Constitution, it says the electors, that is, the electors in the Electoral College, who are in each state, the votes that voters give is translated into a vote actually for electors who are pledged to vote for a particular candidate. So it says the electors shall meet in their respective states and vote by ballot for president and vice president, one of whom, at least, shall not be an inhabitant of the same state with themselves. Okay, so interpreting that 12th Amendment for you, remember when people vote in the general election for president and vice president, they are not directly voting for the candidate. what they're doing is in each individual state, they are voting for a slate of electors. These are individual people who are pledged to vote in the Electoral College for the candidate that they're backing. So if you're in New York and you were voting for Kennedy Shanahan, what you're actually doing is voting for these people who have been chosen by the Kennedy campaign as electors to vote in the Electoral College if Kennedy gets the most votes in New York. So these electors cannot vote for two candidates who are both from their own state, that is the elector's state. In many states, this isn't going to matter much because neither candidate is claiming to reside anywhere other than New York or California, so only in New York and California would this be an issue that electors are going to be voting for someone from their state. It's not, as people have often said, whether the two candidates are from the same state, but whether both of those candidates are from the state in which the electors are voting. So, in other words, when the electors of New York, if Kennedy got the most votes in New York, his electors could not then vote for both candidates if they both reside in the same state as those electors. Was that clear? I hope so. I don't know how else to say it. So the problem is one that's unique to New York and California, but because the decision was about residency based on state law, Kennedy is arguing that residency should be based on the constitutional law. Now, I have no idea what the constitutional law regarding residency is. I don't know if this is a question that's ever been come to the courts, if they've ever had any legal analysis, if there's been any legal analysis of what residency means within the meaning of the Constitution, but it probably is something somewhat different than the requirements in the various states, because they would be, each state might have its own elections code determining how they're going to say who's a resident of a state and who is not. So where are we at here? What's really implicated here, and this could be interesting if this is raised in the federal court. Now, Kennedy's going to appeal from the state court system to the federal court system, and he's going to raise this constitutionality question about what the Constitution actually has to say about the meaning of residency. I'm not sure what the argument about that is going to be exactly, but I know that what they're saying is that it overrides state law. And here, earlier this year, the Supreme Court decision about Donald Trump being kicked off the ballot in Colorado is going to be one that could possibly churn up a lot of issues. So let's go back to that. This was the case that was decided in March of this year of the Supreme Court of the United States, Donald J. Trump versus Norma Anderson et al., who were bringing a challenge to his presence on the ballot in the state of Colorado. And the argument here was that because Trump had encouraged on January 6th this protest at the Capitol, protest of the casting of the electoral votes that went violent, that became violent and very disruptive. They were saying that because Trump encouraged an insurrection against the national government by trying to interfere with the peaceful passing of the presidency, of the election of the new president, that he was guilty of insurrection and therefore would be disqualified from holding office according to the Section 3 of the U.S. Constitution. And the Supreme Court decided that, well, each state, let me look at some of that decision in detail here so we can see. Okay, this is a long passage from that Supreme Court decision, and let me read off the key passages, especially even if you're watching this in video form. I got a long section here, so that's probably pretty tiny and hard to read. They say in part, but state-by-state resolutions of the question of whether Section 3 bars a particular candidate for president from serving would be quite unlikely to yield a uniform answer consistent with the basic principle that the president represented all the votes in the nation. So in that decision, they're saying that when you let the states determine an important question about eligibility for the ballot, state by state, they're likely to come up with different results based on their different laws and court decisions. a little further down, conflicting state outcomes concerning the same candidate could result from in differing views of the merits, but from variations in state law. Okay, so state law can be different, and that's true in this case in New York, that in other states there may be different views of residency, so that Kennedy would be held to different standards in different states. Down even further, the result could well be that a single candidate would be declared ineligible in some states, but not in others, based on the same conduct and perhaps even the same factual record. This very much applies in the case in New York, that if New York determines his residency on a petition based on their state election laws, and then Pennsylvania, say, or one of the other states, Illinois, for example, determines otherwise, and they say, yeah, this is his actual residence based on our interpretation of our elections laws, you can come up with different results. And they say the patchwork that would likely result, this is talking about the Trump case, the patchwork that would likely result from the state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. But in presidential elections, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast, for the various candidates in other states, and evolving electoral map could dramatically change the behavior of voters, parties, and states across the country in different ways and at different times. So that was what the U.S. Supreme Court decided in that Colorado case regarding Trump being kicked off the ballot for having engaged in insurrection and therefore being ineligible under the Constitution to serve as president. They made a big deal about how different states could make different decisions based on the same factual record, which would mean that that candidate is appearing on the ballot in some states and not in others, in a patchwork of decisions that are going to lead to changes in voters' behavior here, meaning, I assume, that if you think a candidate's not going to be present on all the ballots in all the states, you think, well, they're less likely to win, so I'm less likely to vote for them. So it could affect the outcome of the election. Now, they made this decision for a major party candidate. Are they going to apply it consistently to minor parties as well? If that holds up, if Kennedy takes this all the way to the U.S. Supreme Court and brings that up as a precedent, it's going to be hard for that court to then find a way to say that this is different than what they decided in the Trump case. Both seem to be clearly about how different states' laws about how presidential candidates get on the ballot could result in differing outcomes, and therefore, it could affect the outcome of the election. It would seem that the court's logic would imply that they have to strike down all the state laws regarding candidates' eligibility to be on the ballot and apply some kind of uniform law that the U.S. Congress would have to pass. That is, the implication is that the U.S. Congress would have to determine how and in what way candidates for the presidency, not for other offices, because every other office is within a state, not nationally. Vice president and president are the only national offices that are decided by all the states. Congress would have to pass a law determining how eligibility is established and make it uniform across the country. So that is where we're at with this case. I think it will be interesting to see how it goes forward and what happens with this. It could be a major decision that's going to affect presidential elections across the decades to come and make it much easier for independent and minor party candidates to determine what they have to do to be on the ballot in the various states, have a uniform set of requirements that they have to meet, make it easier for them to meet challenges and plan in advance of how they're going to do this, and get rid of all this state-by-state stuff that independent and minor party candidates are subjected to that major party candidates don't have to deal with. So either the Supreme Court is, I think, going to have to determine that the states can't have various eligibility requirements for presidential candidates to get on the ballot, or they're going to have to somehow make a distinction between minor party and independent candidates and major party candidates. That would be, I think, logically hard to uphold and clearly, even more clearly, partisan in its implications. Yesterday was big news for ballot access in general. Here's another case that in North Carolina, a judge rejected Democrats' attempt to keep Kennedy off the ballot. So that went on. On the other hand, in Washington, the Democratic Party is pushing to keep Kennedy off the ballot there in Washington State. And there it's, let's see, it has to do with the fact that they say it was not a convention that the We the People Party held. They were just signing petitions person by person. And Kennedy's arguing that in the past, this has been the standard that, you know, as long as they're announcing that they're going to be petitioning in a place, that can be considered a convention. In other places, there's other considerations. Also, I don't want to leave out some of the other candidates, that this is according to Ballot Access News. The Cornel West won his ballot access lawsuit in North Carolina, so he should be on the ballot in North Carolina. And in Nevada, the Green Party won a ballot access lawsuit as well. And I do not know what the details of that case were. I wasn't even aware that there was a case against the Green Party in Nevada. So that is it for my special report today. Boy, a lot happened in one day. Things are picking up with ballot access, and we'll see going forward. If I'll see you this weekend, or you'll see me this weekend. I'll be producing another video about the events of the week, and maybe even beforehand if something's happening. So thanks again for watching, and I hope you check in again soon.